may be seated.
Well, good morning again, and for those of you that weren't here earlier, let me ask everybody, please be careful to turn off all cell phones or put them on silent mode at least, so that they don't make disruptive noises during the course of arguments that may be presented. We have a very interesting case tonight, like the first case, very important, and each side has 20 minutes to argue. We do have a timing device on the bench that will help you, assist you, and keep you up with your own time. At the end of 20 minutes, if you go that long, then we will sound the bell, and that'll signify the order time is expired. Now, Ms. Barnes, call the next case.
S15A 1739, Benjamin Finney versus the state. Andrew Fleischman for appellant, Paula Smith for appellee.
Hold on just a second, Ms. Blackman. Looks like you got some competition.
Thanks, sir.
How about make an announcement out there in the hall that everybody wants to come in, please come on in.
Yes, Ron, we're
All right. All right, so you may proceed.
May it please the court. My name is Andrew Fleischman. I'm here on behalf of Benjamin Finney. This is a pretrial appeal from denial of motion to suppress. And the issue here today is actually very simple. Something any school...
Speak up a little bit, please.
I apologize.
Thank you.
And the issue today is actually very simple. Something every school child in the room is probably familiar with. What's a good excuse for turning something in late? So in this case, state and federal law requires that when the government gets a wiretap against a private citizen, as a prerequisite for admission at trial, it has to prove either that it immediately sealed the wiretap information upon expiration of the warrant, or that it has a satisfactory explanation for not doing that. In this case, the state sought a warrant on February 7th. Kimberly Schwartz, the prosecutor, did. She afterwards said that her role became peripheral. She said that before the execution of the warrant, her role was peripheral. She briefed the officers and then she let the case go to something else. Someone, we're not sure, asked for an extension on March 7th from Judge Ennis, who was not the initial issuing judge. Judge Ennis, after completing his analysis under 2518.5, issued a new warrant that extended the previous one up to April 7th. Now, the state completed its investigation on March 20th when it arrested my client and his co-defendant and notified them that wiretaps had been signed by Judge Ennis and by Judge Self, that those wiretaps would reveal information about them, including 3,318 calls. So at that point, the state had about a 2.5-week deadline until April 7th to seal these wiretaps. And they didn't do that. Ultimately, the wiretaps were not sealed until April 23rd. This wasn't discovered by defense counsel until 6 years later, when the tapes and everything inside were finally unsealed. At that point, she moved to suppress, and the state gave 2 satisfactory explanations, or what said would be explanations. The first was that Kimberly Schwartz was lead counsel in the case, she was solely responsible, and that she was preoccupied with the death penalty. So she just didn't have the time or the resources to seal the wiretap on time. The second was that Judge Silk was unavailable from April 7th to April 10th, and as a result, the warrant of the wiretap could not have been sealed to them before April 14th. But both of these excuses have serious problems. The problem with the first excuse is that Kimberly Schwartz swore under oath that her role was only peripheral. She believes that the sealing documentation was written by someone other than her, and the state conceded that in their brief. Lieutenant Black swore under oath. Lieutenant Black, do you know when you sealed the wiretap for Ben Finney? Answer, it is dated the 23rd. The evidence receipt on here is dated the 23rd. Question, so you or your staff sealed it on April 23rd, 2008? Answer, yes, ma'am. It's on transcript 4, page 41, lines 14 through 20. So the
Something that happened with this particular part of it, the trial court ruled against you on this particular issue. To what extent, if any, should we give any deference to determination by the trial court?
Well, Your Honor, I believe we should apply typical Miller deference under suppression standard here in Georgia. There's 3 good reasons for that. 1, in suppression hearings, we generally apply clear error to the facts, de novo to the law. That makes sense. It's worked for us. 2, it provides meaningful review above. If we adopted the state's clear error standard, under Georgia law, clear error means any evidence to support it. So even a ridiculous reason could clear the clear evidence standard. The judge could say, well, the prosecutor is left-handed. I don't believe left-handed prosecutors. She's produced evidence in the record that that's true. And the higher court would have to accept that legal justification because there was evidence to support it. It just doesn't make sense. And that's also why the majority of federal circuits, as outlined in Coney, have adopted that. So here, yes, we have a clear error standard with regard to the evidence presented by the judge. And the only...
I assume you're also going to argue that there's no requirement for harm. Is that right?
That is correct, Your Honor. Under Ojeda Rios and under 2518, there's a separate requirement that you take steps to make sure the tapes aren't tampered with. And then in addition to that, you have to either immediately seal the tapes or provide an explanation for why you didn't do that. Those harms are totally separate. And even if the defense has no evidence that tapes have been tampered with, the purpose of the statute under Ojeda Rios was to prevent the possibility of tampering by putting this burden on the state to meaningfully protect the privacy of citizens. So here we are, and we have all this evidence suggesting that Kimberly Schwartz was not solely responsible. In fact, she says she isn't. Even the state's prosecutor, Sandra Madsen, at one point tells the judge, of course, Kim Schwartz was the initial prosecutor of the case. She worked the dope side of it, and then it turned into a murder, and I got into it after that at transcript 5, page 24, lines 8 to 11. So you have 3 separate witnesses saying that Kimberly Schwartz is not acting alone in this case. And even if under Miller deference you say, okay, we have to go with what the judge said, if there's any evidence at all to support it, and there's some scant evidence that it does, how can an explanation be satisfactory if it requires that 3 states' witnesses relying on the state? How can we get to that?
Well, let's assume that she was the responsible ADA and that she was busy. The state cites some cases that say that's an excuse, but there seem to be more recent federal circuit cases that say that's not an excuse unless the ADA's busyness was, very unexpected.
And that's a great point. So that's a Third Circuit case where the Third Circuit Court of Appeals ruled basically anything that's not unforeseeable, ordinary duties aren't going to excuse you from filing the wiretap on time. That's a sensible ruling, Your Honor, because otherwise a devious prosecutor's office could assign every wiretap to the busiest prosecutor. And at what point then could you get redress for failing to properly immediately seal the tapes? So, yeah, but the more recent authority does say that simply being busy isn't enough. But more than that, Your Honors, the only evidence the state presented at the hearing that the prosecutor was busy was her statement that she was lead prosecutor in a death penalty case. That's it. Does that standing alone mean that she's busy? No, that inference is not reasonable. And the reason for that is that, for instance, the case could have been up on interlocutory appeal. Someone else could have written the brief 3 months earlier. There could be an oral argument that the state can't even say she attended. We have all these X factors, stuff that was not presented by the state. And now for the very first time on appeal, they're saying, oh, we've discovered this oral argument on April 15th. That explains it. But Ellijay Rios says, I'm sorry, the state is bound to the excuse they gave at the trial level. And here, that excuse simply isn't very good. As for the second excuse given by the state, the excuse that Judge Self was unavailable, Judge Ennis signed a warrant. At that moment, he was supervising it. In fact, his warrant application said, this court hereby issues a warrant. And Judge Ennis had no explanation for why he wasn't served with these tapes. There's nothing in the record to suggest that he was unavailable. And in fact, some circuits have held that the unavailability of a judge, the Second Circuit has held this, is not a particularly good excuse when you can just go seal the evidence with any other judge. So for these reasons, really, the explanation given by the state isn't satisfactory.
And you know, what we try to do in some of these cases, in most of these cases, on reviews, we try to provide some predictability and certainty in the law. And if we approve of this conduct, we would be assuring some predictability and certainty in the law. What would be the adverse consequences of that?
Ensuring a bad result consistently is consistent, but it's not necessarily the goal of the court. So saying that the state can simply say, we're busy, we're preoccupied, how can the state take its duty seriously when all it has to cite to get out of sealing the documents immediately is that it's busy, or that a judge is briefly unavailable, without even in the record showing any causative effect? There's no testimony in the record, for instance, that somebody tried to contact Judge Self when he was unavailable. There's no evidence that anyone even noticed. Now, what we have is Kimberly Schwartz saying, at some time during my tenure, at 6 years of Bibb County, Judge Self was unavailable. And I think it could have been in this case, and I think it could have been this time. But you know, there's actually a problem created in the record by that, because the state went to Judge Ennis for the warrant extension. So it either did that because it had a policy that it's fine to go to any judge on these wiretap cases, if that's okay, in which case their argument about Judge Self later doesn't make sense. Or they did it because that was the occasion that Judge Self was unavailable during the course of electronic surveillance, and that was the time they had to go to a separate judge. Either way, the argument really doesn't hold up under scrutiny. And for these reasons, Your Honor, under Ellijay Rios, under the clear text of 2518, I believe we should enforce the law as written. Say this excuse is not satisfactory. Unless there are any questions, I will remind my time.
Is there any evidence whatsoever in the record that the recordings were either tampered with or even subject to being tampered with?
No, Your Honor. Under Ellijay Rios, that is not required. And the reason for that is it's presumably quite difficult to prove that tapes have been tampered with. You know, these are thousands of calls. 7 years after the fact, my client would have to listen to these 3,000 calls and determine which ones have been altered or are different. You know, Justice Brandes said in Olmstead that a general warrant is a puny tool of tyranny compared to wiretaps. Because there's no better way to get everything in a person's life, their family, their friends, people they talk to. These protections are here for a reason, because citizens need to be protected from this surveillance.
Counsel, the state says that the record not only fails to show any actual evidence of tampering, but in fact, the record shows that this was essentially tamper-proof, that there was an officer who testified it couldn't have been altered, and there was no opportunity for tampering. Do you agree the record shows that? Is the record undisputed on that point?
You know what, Your Honor, I don't have any proof of tampering. There was no opposing testimony to say that the tape could have been tampered. It is undisputed. But under 2518AA, that's a separate requirement. You have to take steps to make sure the tape isn't tampered with. So if they hadn't done that, that would be a separate reason to go ahead and move to suppress. Similarly, if the tapes had been tampered with, that would be a reason for me to move to suppress if we have a hearing. Now we have a third reason. They failed to immediately seal the recordings, and that's just as firmly in the statute. If there are no further questions, I'll reserve my time for that.
All right, you may do so. Mr. Smith?
Mr. Chief Justice, may it please the court, I'm Paula Smith here today on behalf of the state, urging the court to affirm the trial court's denial of the motion to suppress in this interlocutory appeal. And before I address the issues, I would like to answer your questions in the order in which they were asked. Justice Benham, in the North case, which is cited in the state's brief, 250 Georgia App 622, the court there used a de novo standard of review for looking at this precise issue regarding sealing. And my review of the circuit courts, that seems to be the test that most of the circuit courts employ, which means that historic facts are subject to your clearly erroneous rule, i.e. is there any evidence in the record to support them, but it's also the reasonableness or the application of the law is something that you do de novo. Second, Justice Namias and Justice Blackwell, there is no evidence of any tampering. There was no suggestion below of any tampering. That was not any basis upon which the motion to suppress was filed, even though it was like a 4 or 5 challenged motion. The one that was distilled and is before you today has come down simply to the issue of delay. But the testimony of Officer Black is very clear that with the technology used today, these tapes, as they're being intercepted, the conversation is being burned onto the CD, and it is almost tamper-proof. There was also additional testimony about how the person who was the monitor would have to log in, and that summary would be entered by that individual as it was being done. Once that was closed out, it couldn't be tampered with or gone back into if there were any corrections, such as perhaps that wasn't the voice identified initially. Then a separate summary would have to be entered either by that same person or someone else, so you've got layer upon layer upon layer.
What about the whole CD, or a whole, not that what was on the CD was tampered with, but the whole CD is gone?
The CD itself. That is a different situation, Your Honor, and I don't think there was anything that was touched upon here.
There's no evidence of that, but is there
No.
anything that would absolutely guarantee against that?
Well, actually, one of the cases that we cited, it turns out that the CDs were defective and did not record. That was part of the reason for the delay in trying to sort of reconstruct, go back and reconstruct some of that. I don't recall which one of the cases it was, but that was something that actually did arise.
And what did, I think someone asked about harm. So the tampering part of it, how does that figure into the analysis? Because we seem to have said, in accordance with the U.S. Supreme Court, that that's a separate issue. The government has to show it wasn't tampered with, but the fact that there was no harm whatsoever doesn't mean that the state wins.
Absolutely, Your Honor. And in the Rios case, the United States Supreme Court said that the fact that you may give an explanation for the delay and show an absence of tampering didn't satisfy the congressional intent in requiring that the return be made immediately to preclude the opportunity to tamper. We have two it is a very narrow issue before you, and turning to the reasons upon which the trial court made its fact findings and conclusions, looking at the affidavit of Kim Schwartz, who was the prosecutor at the time, counsel neglects to point out that her affidavit itself was given 6 years after the fact. She was already employed in another circuit. She did not have access to her files. The affidavit that she executed, and it's clear from the content of the affidavit itself, at pages 142 and 145 of the record, that she didn't have access to a file, and basically all she reviewed were what I would call the alpha and omega documents, basically the initial application for the investigative warrant, the affidavit, the date on which it was signed, which was February 28, 2008, the extension request, which was signed by Judge Ennis. Then,
But counsel, whose burden is it to make out a reasonable explanation?
it is the state's burden, Your Honor, but the Coney case that the state cited in its brief also allows for the fact that the lack of particularity can itself be explained sometimes between the link between the event and the explanation being given.
I mean, the problem I have with that is we have said in a number of cases in the context of ineffective assistance of counsel, cases your office is very familiar with, it relies on all the time, that a silent or ambiguous record, a hazy record, maybe because witnesses don't recall things as well, but a silent or ambiguous record is not sufficient to carry the burden.
I'm well aware of that, Your Honor, and she specifically said in her affidavit, I don't recall the reason for the delay at page 147. But I don't think that in and of itself is enough to defeat or preclude the giving of a satisfactory explanation. Turning to the reason that she did recall the specificity was the Fair case. which was a high-profile death penalty case. There were 2 defendants. And I would point out, we're not the ones who have broached the Fair case as being a reason, apart from the fact of where it was pending. This is not something that we have raised in the appeal. It was simply something that she noted she was preoccupied at this point in time with the Fair case. That was something she did recall. It's counsel in their brief for the first time on appeal and ask you to actually go behind or go outside this record and look at your records to see when the appellee's brief was filed in the Fair interlocutory appeal. That is in the appellant's brief. And the state in its brief, I would submit that to go outside the record and rely upon something that was not presented and argued below nor considered by the judge would be improper. But even alternatively, if you taking judicial notice of your own records, the state pointed out in its brief that there was also a letter brief which was filed by Fair's attorney which referenced an oral argument in the week of the very first week that the warrant had expired and return would be made.
Even accepting that she was working on a death penalty case, the problem I have, you cite a couple old cases that say the prosecutor being busy is a satisfactory explanation. The busyness of the prosecutor in those cases, as the Third Circuit pointed out in a more recent case, was not something that is an everyday experience of prosecutors everywhere. It was very unforeseen. In one of the cases, there was a leak of the wiretap, and all the investigative resources turned for a period of time, including the prosecutor and the agents, turned to investigating why the wiretap got leaked. And in the other case, it was similarly unforeseen. There seems to be nothing in the record that suggests that this prosecutor's work on the Fair case, even assuming she was very busy with it, was something that, you know, it would happen every day. There's no indication that some big issue popped up, you know, and she had to turn all her attention and there was no one else available.
Well, Your Honor, again, I think I acknowledge that the more recent decisions look past the fact that there was a workload or something unforeseeable thrust upon a prosecutor and had looked at things more in depth. But I think what we have in this record, again, is the prosecutor trying to recall what her schedule was like 6 years before. Again, not as an excuse or as
Well, I will
an
give you,
presumption, but
taking the best inferences available, as the trial court seems to, I will give you that he said she was very busy at that time. But there is not even a scintilla of evidence that I see that her busyness was unpredictable or unforeseen. And if we were to bless the busyness of the prosecutor, I used to run an office that did more wiretaps than any other U.S. Attorney's office in the country. Those people were really busy. If we could say, well, we just, you know, we never seal stuff on time just because every one of them is really busy, you know, there would be no limit to the excuse. Every prosecutor in Georgia is pretty busy.
I would acknowledge that, Your Honor, but I think, again, given the circumstance, the lapse of time, she made it very clear she could not recall the specific reason.
Well, then you run into Justice Blackwell's problem.
Exactly.
is then what, is there any positive evidence in the record that her busyness was unpredictable, or that there was no one else in the office who could have gone and had the sealing? Because also the federal courts seem to say pretty uniformly that, you know, there's no magic in the individual prosecutor. The sealing process takes very little time, very little expertise. It's carrying stuff from the investigators to the judge and presenting it and saying, this is it. So how many people were in the DA's office?
Well, what we do know from this limited record, but that there were 3 assistant district attorneys involved in this process.
In this particular case,
In
there
this
were 3.
particular case, but otherwise, I would be going outside the record, Your Honor, and speculating. And I would point out that I think an interlocutory appeal is somewhat more unforeseeable than perhaps a direct appeal in a case. I don't know the timing. Again, we're going so far outside the record in
Well,
this
but to
case.
go back to that,
and-
it was the oral argument in the interlocutory appeal,
Absolutely,
right?
Your Honor.
Which means that it would have been set at least a couple months ahead of time. It's not the actual interlocutory appeal, which you only have 20 days to file, but the actual oral argument, which you have months' notice, like you did for today's argument. I mean, could you, if you were working on a wiretap, say, well, I had an argument scheduled 2 months off, and so you're a very busy prosecutor. Could you have said, I don't have to seal things for week after week because I'm busy?
No, Your Honor, I think what you have here, and I think if you look back at your decision in Fair, it was an extensive, and there were some weighty constitutional issues involved in that, out of the ordinary. It was not a simple one or two issue case but more importantly, I think what you have is the juxtaposition of when the extended warrant expired on April 7th, and it looks like oral argument was before you on April 15th in the Fair case. All we have in the record is what she has set forth in her affidavit based upon her limited recall, her limited access to the files.
Ms. Smith, what is your most persuasive argument as you view it on behalf of the state in response?
I think, Your Honor, that if you look at the definition of what is a satisfactory explanation that the circuit court followed in the Coney case, because that is something that the United States Supreme Court has not given a definition of. It is something that the circuit courts, as best I can determine, have not formulated a test where there's a consensus. And basically it said what we really want to do is to make sure that the explanation dispels any reasonable suspicion of tampering, and whether it is plausible and whether it is genuine. And I think under the circumstances here, the judge was correct in finding that the explanation given, in addition to Judge Self, who had been the issuing judge, not being present for part of that initial period. And again, Justice Namis, I'm aware that some of the circuits, there's a split among the circuits.
Well, there's not really a split anymore. The early cases said that the judge being unavailable was kind of an uncertain thing, so we're going to let the state say, we didn't know whether we could take it to a different judge, and that's our excuse. And the early cases said, okay, well, that was a good faith excuse, the law wasn't clear. But the later cases, including in the same circuit, say that's no longer an excuse because we've now made it clear that you can take it to a different judge. And it's also a pretty lame excuse when you took the case to a different judge, right?
Well, we don't know, and as counsel even pointed out, we don't know who applied for the extension and how or why it was taken to Judge Ennis.
But the fact of this particular case is the statute speaks of issuing judge throughout, including for extensions. So you took it to a different judge. I mean, if your argument is only the issuing judge could could seal it, then the extension warrant is invalid, right?
Well, I'm not making that as a per se legal argument, Your Honor. We're simply looking at the facts of this case. Apparently, that was the perception everyone seemed to be operating under, because even if you go past the prosecutor's affidavit, where she thought she had stepped out of the main role and simply took the return to Judge Self, if you look at the order, she made corrections on the order itself, so she did review it. There was more participation than she would call 6 years after the fact. I would also simply point out that counsel has also, for the first time on appeal, challenged the fact finding that Judge Self was unavailable for 4 days within the first week when the warrant expired. That argument was not raised below. Now that the record has been supplemented with the post-hearing briefs filed by the parties, it's very apparent that a lot of the questions and the arguments presented to you about the sufficiency of the facts were not raised and ruled upon below, and he has not overcome the burden to show that they're clearly erroneous. That in and of itself doesn't answer the question of whether you think, as a legal matter, there's a satisfactory explanation. But we submit that the trial judge in this case found the reasons plausible.
But he found them plausible based on the legal theory that the absence of the issuing judge is okay. Citing cases you probably cited to him, including from the Second Circuit, Rodriguez, that a later Second Circuit case, which you may not have cited to him, says that is no longer a valid explanation. And we assume that prosecutors will be familiar with the law, and so while there might have been some uncertainty, there's no uncertainty anymore.
I think the Ninth Circuit, with all due respect, Justice Nami, still recognized that, and those cases were cited as well, in addition to Second Circuit. Again, I think there was a perception that it was to be returned to Judge Self. All I know is what is in the record. I don't think there's been any showing by the appellant that the facts are not, that the judge found below are not supported by the record in this case.
Can I ask you, there's there's the trip that the judge was on, and there's the business of the prosecutor, but those days don't fill up the entire window of time for the delay, as I understand it.
You're correct, Justice.
And most of the cases that talk about satisfactory delay really talk about excusing maybe 1 or 2, maybe 3 days. Is there any explanation for the additional days, and how do we, or does that explanation cover the full scope of some form?
Well, there was no specific explanation given, Justice Melton, for what happened once Judge Self was back in town, who would have been available April 14th. The argument, I think, in the Fair case, if we're going outside the record, was April 15th, but there was still nothing until April 23rd, and there's a consensus in the circuit court to exclude the weekend, so we're talking roughly, whatever the math is, I think a period of 7 days. The record is silent.
So even if we accept everything, that would excuse some of the delay, but there's still some days that are unaccounted for.
In this record, there was nothing affirmatively given, Your Honor, and again, these cases, I think there's no magic number of days. I think there have been cases in which delays were longer. It depends on the explanations given. I think that any delay of 1 or 2 has been found by the 11th Circuit and 3 other circuits to constitute immediately, just as a practical matter. But apart from that, I don't think that there's anything magic in the fact that it was 7 versus 2. It's just what we have in this record.
Ms. Smith, in a multi-judge circuit, the other judges will handle these situations with some frequency, will they not?
Well, there's a footnote in Judge Ennis's order denying the motion to suppress. He said ordinarily the practice in that circuit is for applications for investigative warrants to be signed by the judges in the narcotics division
But they
of
can't.
that bench.
There's no legal reason that they cannot do that.
No, not that I'm aware of, Your Honor. This was just simply how they apparently did things in Macon, which was, again, part of why
Procedure
the
that they followed.
ADA thought it was, she could remember trying to find Judge Self, finding out unexpectedly he was out of town, and she thought it must have been his case, because he ordinarily was not involved in a situation like this. Again, we're working with the limited record as to what is there.
Can I just ask kind of a summary question? I mean, there's a lot of lack of knowledge of the law, there's a lot of empty holes in the record, there's a lot of sloppiness in compliance. Assuming we find all that to be true, you concede that the fact that there appears to be no harm whatsoever to the defendant's rights, other than that the statute wasn't complied with, that would require reversal.
Well, if you read Rios that strictly, Your Honor, that's what the Supreme Court said, that we didn't look into harm, even though the court said it would have the opportunity to do so. There are also some of the circuit cases that we've cited that start looking at the fact that there's no harm. It's not part of the satisfactory explanation, but when there is no tampering, it's something to take into account as well. And it seems that courts, when they have looked at that secondarily, have been more forgiving and more inclined to allow the admission of such evidence. If there are no further questions, we urge you to affirm. Thank you.
Thank you. Wayne, you rebuttal?
Briefly, Your Honor. First, I'd like to say, of course, we concede that the trial court found that Judge Self was unavailable, and we concede that, yeah, there was some slight evidence. We just pointed out in the brief that the evidence, which was a piece of paper with some check marks on it, was pretty flimsy evidence that he wasn't there. But under clear error, that's probably enough. The state goes back to Coney a lot. I read from Coney, I don't really see it applying to Ojeda Rios analysis at all. In fact, it doesn't seem like it really treats it as precedential. Of course, Ojeda Rios has some binding effect on this court, and Coney doesn't. But Coney basically says, well, unless you drown your tapes in a bird bath and you're after the FBI's number one suspect and it's very suspicious for all these reasons, I'm basically never going to find that you have to follow this because there won't be evidence of tampering. I don't think this court should follow that rule because I think Ojeda Rios stated a clear and decisive rule that tampering is irrelevant. Moving past that, the state says, well, we have a satisfactory explanation for why we don't have a satisfactory explanation. A lot of time passed. And the real problem with that is there's no explanation then. If you know that you're 16 days late, why don't you write it down somewhere? Or reason? Why did you disclose to opposing counsel? Why don't you do something to memorialize that? So if it comes up, which it should, if opposing counsel does their job, you can talk about the reasons. Well, there's two reasons. One,
Mr. Fleischman, are you arguing to this court that simply Rios governs and they can't, and the state cannot get around Rios? Is that your argument?
that's my argument here. So moving, I'm sorry. So either they didn't disclose it because they forgot or didn't realize that the rule was important, or they were hoping the opposing counsel wouldn't know. So it's really the only two reasons. Those don't seem like good faith reasons you can come back on 6 years later and then say, oh, we should be excused all this time passed. Ultimately, we have a lot of young attorneys here in this room, and young students, people whose job it is to turn things on time. And the question is, will this court create a rule that encourages them to create lame excuses at the last second, or a rule that encourages them to be professionals in the moment? Thank you.
Thank you. Please have a seat for just a minute. Let me, on behalf of the court, thank both sides for your excellent presentation today. And we carefully chose cases to hear up here based, to some extent, on how well we thought the attorneys would do. And we appreciate very much you fulfilling that dream that we had, that we would have a very articulate and very well-crafted argument for the court. Appreciate your briefing, but know that your help in this matter will be very instrumental for the court reaching a proper and right decision. To the students, let me say that I know that all of you have read the briefs. I know that you have read sort of a précis form of these cases. The Supreme Court of Georgia has 3 terms a year, and we have by constitution a requirement of actually deciding cases by the end of the 2nd term. So we can't sweep things under the rug and say, well, that's just too hard to tackle this term. We have to get it out. I know that you won't get out of your term in school this year until sometime late spring. These cases should be decided by the end of March. So once they're decided, we'll try to get copies of this back to your school so that you can discuss it further. And hopefully that will add to the learning experience that you've already accepted in studying and coming today. Let me say to everyone in the audience that the Supreme Court of Georgia was approved by a constitutional amendment back in the mid-1830s, and it took about another 10 years for the legislature to actually fund it, pass enabling legislation. I think there was some tension and fear by the legislature that the Supreme Court might decide cases that would hold acts of the legislature unconstitutional. But be that as it may, it took a while for them to finally agree to do that. And for about the first 20 years, till the end of the war between the states, the court traveled around. It had no home. It just sort of traveled around the state and held court in different locations. We would hear arguments like we did today, and then issue a decision. Go back to Atlanta or somewhere and write it up and put it in the law books. At the end of the war, though, there was an act of the legislature that required the court to sit at the state capitol. And so Milledgeville, my home, was the state capitol at that time, and the Supreme Court sat for about 2 years there until 1867 when Atlanta became capital, and it moved up to Atlanta. But it's part of our tradition of this court for us to go around and visit and hold court. We try to go to one of our law schools every year, and we try to go to other places in the state every year so that people such as yourself can be first-hand witness to what we do and how we do it. But we want to thank all of you for your attention, for your interest, for your citizenship and actually coming and being a part of this. A lot of times I tell people I used to be a circuit court judge, used to be somebody, and I would tell people that the very few opportunities most of us have to actually participate in our state government. One of them certainly serving on jury service, and I encourage you to do that when you get an opportunity. Another one's paying taxes. Well, we don't like to do that, but it's necessary. And another one, I think, is actually going to vote, so I encourage you to do that as well. But every opportunity you have, you can also run for office, but every opportunity you have, I think you should take pride in your government. And for those officials that are present, we want to thank you again for all you do for citizens of your community and citizens of Georgia. I want to again thank Chief Judge Weaver, Judge Bradley, and Judge Mercier. Thank you very much for your kind invitation. We appreciate it, and we have enjoyed our stay. And I hope that we have given some glimmer of insight into the work we do. But thank you very much, and to all of you, I bid you a good day.
All rise. Be seated for